Okay, well, good morning, everybody, and welcome to this edition of Case Downtown. I'm Catherine LaCroix. I ought to introduce myself a little bit. My practice background is as an environmental lawyer, and at Case, for the last 20 years or so, I've been teaching from a menu that includes a steady diet of federal courts, generous helpings of teaching environmental law, and periodic forays into land use as a subject matter, which I am teaching actually this fall. And then I'll have time over the break to rearrange my head before I do federal courts in the spring. But you'll notice that today's topic doesn't really have anything to do with any of that, except insofar as it intersects with federal court jurisdiction later in the talk. And the reason is that when I was asked, hey, you want to do a case downtown? And by the way, what do you want to talk about? I found myself thinking about the year plus I spent as the petition drive coordinator for the League of Women Voters of Greater Cleveland, working on congressional redistricting, and then as a coordinator of our effort to promote what was then issue 1 on the May ballot this past May. And I thought, that's an interesting topic. And also, if you're busy, as most of you are, you might have watched the news or, in summer of 2017, been approached by somebody with a clipboard and learned, oh, there's a petition drive. And then in May, oh, look, we're voting on something. It's on the ballot. I wonder what it is. And then right after that, there's a lawsuit? What the heck is going on? So this is my effort to sort of straighten it all out and put it into its legal framework, because there is a fairly, not complex, but useful legal framework surrounding all of this that starts with the federal Constitution, an important Supreme Court case, and then some critical elements of the Ohio Constitution. And those parameters dictated the various events that took place over the past year and a half. So my focus is Ohio, but in the process, I think I'll explicate or maybe help explain the relevance of the recent Supreme Court decisions for us. Okay, so let's begin at the beginning. The United States Constitution, Article 1, Section 4, the times, place, and manner of elections for senators and representatives shall be prescribed in each state by the legislature thereof, but Congress may from time to time say something about it. Okay, so for our purposes, the most significant point here is the reference to state legislatures. The Constitution tells us that state legislatures choose how to draw congressional districts. Now, other parts of the Constitution are relevant also, most notably the Equal Protection Clause for the protection of racial minorities, and then Congress can add requirements and restrictions. But our focus today is the mechanism by which a state draws congressional district lines, and here we see a reference to the legislature. So, okay, why do we draw and then redraw district lines? So this is what we call Redistricting 101. When the nation began, every state got one representative, and then more, as the United States House of Representatives is allocated by population rather than by state. So as the nation grew, they kept adding representatives to the House of Representatives until somebody finally thought, we're getting to be a pretty big country. This can't go on forever. And so in 1911, the number of representatives was capped by statute at 435. That means that over time, as we add population, we add states, we add population, we have to reallocate those 435 among all the residents of the United States. Each state gets at least one representative, but beyond that, we have to figure out who gets how many representatives. And within each state, if you have multiple districts, each district must have roughly the same number of voters in it. So in Ohio now, that means about 750,000 people per congressional district. You can't have 50,000 people in one congressional district and 1 million in another. That's called malapportionment, and that is bad. So they have to be roughly equal in size. And people don't stay put, populations don't stay put, so every 10 years we have the census, people move around, and we reallocate our 435. For instance, Ohio has been steadily losing representatives, not because we're losing population, but because other states are gaining it. So we're reallocating the 435, we lose one. We lost one in the redistricting that took place in 2011. We're probably going to lose another one after the census in 2020. So you redraw the lines, and there are a lot of ways to draw a congressional district line. If your only guidance is each district has to have roughly the same number of people. So partisan gerrymandering has been a regular feature of congressional redistricting in Ohio since at least 1971. It was done 1971, 1981 by the Democrats. In recent years, it's been done by the Republicans, but state legislators obviously have a strong incentive to draw lines, and if there are no limits, they are able to draw lines to shape and favor a particular party or a particular candidate. So this slide you cannot possibly be expected to read. But the main point of it is it's got a whole bunch of boxes and a timeline that starts back in 1967. It lists the 5 partisan gerrymanders that have happened over that span of time. And the main point I want to get out of this is that in 1981, the League of Women Voters began to push for reform to the process to try to get congressional district lines to be drawn in a way that would be more competitive and more responsive to the voters. And over that time, the League allied itself with whichever political party was out of power at the time, because the political party in power had zero incentive to cooperate. So these efforts, there were multiple failed efforts to get reform through the General Assembly, onto the ballot. There were 2 ballot measures that were defeated in 2005 and 2012. The problem each time was that only one party, or perhaps neither party, supported an effort at reform. And so they would either oppose, they would actively undercut whatever was going on. So, right now, prior to 2018, there were no specific procedures in the Ohio Constitution for how to draw congressional districts. And the redistricting that occurred in 2011, taking advantage of enhanced data science available at that time, illustrates how districts can be drawn by the party in power. So this map shows our current districts. We have no gerrymander, but we have a snake along the lake, which goes from essentially Dennis Kucinich's house on the west side of Cleveland over to Marcy Kaptur's house in Toledo. We have a duck. If you look carefully, it's the blue duck. You see that comes into our area and extends, almost all the way to the western side of Ohio. And you can imagine other animals if you like to entertain yourself while you're enjoying your coffee. So how was this prepared? And here I'm going to give you a very brief summary which comes out of public records requests by the League of Women Voters that led to a report by the League of Women Voters. But in a nutshell, these district lines were drawn by a small group of people on leave from their public jobs for Republican lawmakers. They hired a suite in the Doubletree Hotel in downtown Columbus. So the idea was to control access and allow meetings without people being seen coming in and out of the State House. And the map was designed in consultation with the National Republican Party, subject to approval by John Boehner, who's a congressman from Cincinnati and Speaker of the House at the time. And the main goal was to draw district lines that would maximize the number of safe Republican districts. The resulting map was then approved by our Ohio General Assembly, which is itself composed of senators and representatives elected to heavily gerrymandered districts. So the record the public record request produced emails that show various evidence of various special deals. There is, if you look at the duck, there's a little bit there in blue, and in this map it's in a different color. It's District 4, it's in orange. I call it the tongue of the duck. It's a little bit that extended out to include a prison in District 4 to help make up the correct population amount. Prisoners count for population purposes, but they cannot vote. So it's a nice way of boosting the number of people in your district without bringing in any troublesome voters. We have, and then in our area, you'll notice there are 16 congressional districts total in Ohio. Our area has portions of 7. This is an example of what we call packing and cracking. So the way this gerrymandering works is you pack your disfavored voters, these days that's Democrats, into as few districts as possible with as high a density of Democratic voters as possible. And then you crack, as they call the remaining Democrats. And I say Democrats because this is most recent. Had I been talking to you 30 years ago, the parties would have been different. So you have little tendrils of other districts extending into our area to gather up Democratic voters into districts that then extend considerable distances to outnumber the Democrats with voters in areas that lean Republican. You can sort of see that better on this big map if you look and you see the number of districts. Our duck, for instance, why is the duck all the way into our area and then way out at the other end? The duck I keep talking about, by the way, is the blue district. There's also a nice dark green district that comes all the way up into our area and then extends way down. And similarly to the east, the Geauga County area. So that's an example of what we call cracking, where you take a few of your disfavored voters and outnumber them with your favored voters. Now, the resulting districts, and here this is an analysis done by the plain dealer, had a significant impact on elections. It was a highly effective way of ensuring 12 safe Republican districts and 4 safe Democratic districts. And the plain dealer found that this was a resilience of voting patterns that was unprecedented. And also, remember, we're a swing state. This did not reflect the overall partisan makeup of our state. And you can see it even better in this wonderful slide the plain dealer did of margins of victory. Recall that we are a state that in presidential elections, the presidential candidate wins by single digits at most. And yet our closest congressional election had a margin of victory of 18.4%. That means the winner got 18.4% more votes than the loser. In our most lopsided districts, this is packing at its best, the winner had a margin of 60.6%. Our winner got 60.6% more votes than the other candidate. So when people say, hey, why should I vote? My vote doesn't count. When we're talking about congressional districts, by and large, it doesn't really matter. The same party will win. So from the League of Women Voters' perspective, the question is, how do we make the districts more competitive? Because that, from our nonpartisan good government perspective, is the goal. Well, one option might be to go to the state legislature to get better standards and procedures. But that is vulnerable to being reversed by a future state legislature. Even if you do it by an initiative, if it's a statute, the General Assembly can just change the statute. So the conclusion was, well, we have to change the Ohio Constitution. Amendments to the Ohio Constitution, regrettably frequent, but this one was necessary. Amendments to the Ohio Constitution can occur in 3 ways. One is a constitutional convention, which did not happen, so I'm not going to talk about it. The other 2 are as follows. First, we have the initiative process. This is a voter-initiated method, and you really probably can't read all this, but a voter-initiated method. You get signatures from the voters, enough signatures, goes on the ballot. Now, not in all states allow this. This is a critical perspective, from a nationwide perspective, 26 states and the District of Columbia allow initiatives to amend constitutions. 24 states do not. So if you look around the country, you go, up in Michigan, they've got a proposal on the ballot. That's because they have the initiative procedure in Michigan. You look at Pennsylvania, it was a lawsuit. Why? Because there's no initiative option in Pennsylvania. So the available tools shape, obviously, your strategy if you want to get a change. So the key features of the initiative process: you need to get a very large number of signatures, 10% of the total electorate that voted in the last gubernatorial election, which in our case last time was 305,000. And you can't just collect all your signatures in Columbus, Cincinnati, and Cleveland. You have to spread them around the state. You have to get at least 5% of the relevant electorate in 44 of the 88 counties. You have to get all your petitions together with all of your signatures, file them with the Secretary of State 125 days before the next general election, the election in November. Why? Because after that time, after you turn in your untidy piles of paper, they are sent out to the boards of election all over the state to validate the signatures. Are these real voters? Do they live where they said? Can you read what they said? Is there something wrong with the petition? And because signatures do get thrown out, as a practical matter, as a citizen petition drive, you have to get way more than 305,000 signatures so that when you're done and they're winnowed out, you end up with a qualifying number. That's one way to get yourself on the ballot. The other way is that the Ohio Constitution allows the General Assembly to pass a proposal to put something on the ballot. And if it's passed by a supermajority of both houses of the General Assembly, this can go on the ballot 90 days. If you vote it, you have to vote it out 90 days before the next special or general election. So in other words, under our Constitution, if you go this route, something proposed by the General Assembly, supermajority vote in both houses, only 90 days as opposed to 125, and it can go on either the special or general election ballot, which means it can be heard either in our case in May or in November. So there's some key differences between the two ways to get a measure on the ballot. With that background, the League of Women Voters, as part of a coalition called Fair Districts Equals Fair Elections, together with Common Cause of Ohio, started with a citizen initiative. So basically we started with what I'll call door number one, right? Get all the voters, get signatures, get something on the ballot. Now to explain that, I have to back up a little bit to a little history. Back in 2015, you're going, wait a minute, didn't we vote on something in 2015? Yes, we did. League of Women Voter Efforts had a victory in 2015, that is, through bipartisan negotiations within the General Assembly. The Assembly placed before the voters a process to control gerrymandering of seats in the Ohio General Assembly, the state legislature. This proposal went on the ballot 2015, was approved by 70% of the electorate. But this reform covered only the General Assembly, not the congressional districts. I'm going to describe it a little bit because this was the basis for the initiative petition drive. If you signed a petition back in 2017, this reform was the basis for that proposal. The 2015 amendment created a 7-member commission with standards to guide the redistricting process and a requirement of supporting votes for a map from both major parties before a map could be adopted. So the members of the commission, the governor, the auditor of state, the secretary of state, one person appointed by the Speaker of the House, one person appointed by the leader of the minority party, one person appointed by the president of the Senate, and one person appointed by the minority leader of the Senate. So there will always be at least 2 members of the minority party at the table. All meetings of the commission are to be public. There are to be at least 3 public hearings. You can see already a difference between this process and the way redistricting unfolded, in particular in 2011. And there are restrictions about how many times you can split a community among different districts. So there's much heftier public involvement in this process than there was in the prior system. And there are some standards here. specifically in the requirement. You can't draw a congressional district, a General Assembly district, primarily to favor or disfavor a political party. And then there's this awkward language about the statewide proportion of districts, blah, blah, which boils down to, when you're done, the partisan balance of your districts should reflect the partisan balance of the state. You can't have, in a 99-district House, you can't have 70 of them from one party, 29 from the other, if the electorate is divided, 60-40 or thereabouts. So this is what we call representational fairness. Okay, it takes the votes of 4 commission members out of 7 to adopt a plan, and at least 2 of those have to be from the minority party. Now, to repeat, this reform did not cover congressional districts. It was only for the General Assembly. Why? 2 reasons. Number 1, opposition from the National Republican Party, and number 2, a constitutional argument based on Article 1, a good constitutional argument. Remember my opening slide. The argument is the legislature draws congressional districts. We can't let a commission do it. The Constitution says it has to be done by the legislature. Okay. However, in June of 2015, the United States Supreme Court decided Arizona Legislature versus Arizona Independent Redistricting Commission and held that the term legislature in the Constitution does not prevent the citizens, through an initiative, from adopting a different system, in this instance, an independent commission. So the majority held that the term legislature in Article 1 does not mean that only the state's representative body can draw the lines. So with this was a constitutional green light to use an initiative reform and promote a bipartisan commission in Ohio. So the coalition, Fair Districts Equals Fair Elections, developed a proposal based on the 2015 amendment, using that same bipartisan commission to draw the lines, and it added some language for Congress, required the state to make relevant data available to the public so members of the public can submit proposed maps. There are many ways to draw a map, and if you have the data, you can propose a competitive congressional district map. The proposal repeated and included the other criteria in the 2015 amendment, including representational fairness. It required minimizing splits of counties, cities, and whatnot, and instructed the commission to provide a written statement explaining how new lines would satisfy the requirements. So that was the Fair Districts Equals Fair Election initiative proposal. And after some preliminary requirements were met that weren't worth going into, the Secretary of State approved the proposed ballot language late May 2017, and that set off the process of signature gathering. So League of Women Voters and affiliated volunteers all over the state went out to gather the more than 300,000 signatures that we needed to get the proposal on the ballot. So this was a statewide, all-volunteer campaign. I hope somebody approached you between June 2017 and January 2018. Our league, Greater Cleveland League affiliated effort, had 750 volunteers, so we got 45,000 signatures. There they all are. Okay, so we kept track of our progress on a map statewide. This was kept by the folks in Columbus, the League of Ohio and Common Cause of Ohio in Columbus, keeping track of how close we were getting to the 5% in 44 counties. And as the likely success of the signature collection campaign became clear, the members of the Ohio General Assembly created a bipartisan working group on redistricting reform. They held 2 public hearings in October and November of 2017, where there were more than 30 witnesses each time, and every single one favored reform. Nobody said, hey, I like gerrymandering, it's just fine. This is the then executive director of the League of Women Voters at the second hearing in 2017, where after the hearing was over, all the audience members got up and handed their signed their bundles of petitions they'd collected to Carrie. This was not one of these design demonstrations. This was, we're all going to Columbus. How do we get our petitions to Columbus to be counted? What the heck, I'll take it to the hearing. And so everybody did. So in January of 2018, the working group went deep into negotiations. The General Assembly Working Group negotiated with the Fair Districts Coalition, and in that instance, we were represented by the NAACP, the League of Women Voters of Ohio, and the Ohio Environmental Council, as well as Common Cause of Ohio. And the negotiations produced a compromise proposal, which the Ohio General Assembly approved as SJR 5, went onto the ballot in May 2018 as issue 1. So in other words, we didn't go through door number 1, the initiative, popular initiative. We went through door number 2, having the General Assembly put something on the ballot. And it went on the ballot in May. So recall that under the Ohio Constitution, the General Assembly can do this. They can put a proposal on the ballot in May. Had we gone through the popular initiative, we would have had to wait till November. You wouldn't have voted on anything yet, okay? So this measure passed overwhelmingly in May by about 75% of the electorate, which voted yes. So what did we do? Anyway, it's not the same as the Fair Districts Coalition proposal. Not the same at all, actually. It adds a new Article 19 to the Ohio Constitution with a totally new procedure for establishing congressional districts. It has key elements, a 3-tier structure, which I will get to, enhanced public participation, and some standards guiding redistricting. So here's the part that was the hardest to explain when going out and doing a sales job. So this is what I did, what we all did sort of as our best approximation. The first step is that the Ohio General Assembly gets to draw district lines, but they have to be approved by 3/5 of the General Assembly, so a supermajority, including half of the minority party. If you do that, and it has to comply with certain baseline criteria, which I will get to. If you do that, your map lasts 10 years, you're done, okay? If somehow that doesn't happen, then it goes to the Redistricting Commission that we established in 2015, and that group draws a map, and it has to be approved by a majority of the Redistricting Commission, including 2 members from the minority party. And if you succeed then, presto, 10-year map, which satisfies our baseline criteria, which I will get to. If that doesn't work, it goes back to the General Assembly, where you have to get 3/5 again, but only 1/3 of the minority party, last 10 years, baseline criteria, you're done. And as the ultimate fallback, a simple majority of the General Assembly with no minority party support can pass a 4-year map, at which point additional criteria come into play. You cannot unduly favor or disfavor a party or incumbent. You cannot unduly split governmental units. Thank you. We are all wondering what's unduly. The majority must justify how they comply with these criteria. And if it's a 4-year map, the whole process starts over again after 4 years to produce a 6-year map. Okay? Got it? Right. Then it also included some features to protect the public. There's a limit on how many times you can split your counties, and I'm happy to provide details. You have to try to keep your districts compact. The public needs to be given data. They can submit their plans. There have to be at least 2 public hearings. And there are provisions intended to minimize splits of Cleveland, Columbus, and Cincinnati to keep them together to the extent possible. One of the issues with the current map is that the districts don't really represent anybody. There are many cities that are divided in half for redistricting purposes. So you don't really say, oh, this is the congressman from Rocky River. It's like, depends. Are you in the north part of Rocky River or the south part of Rocky River? So the goal is to have districts that are competitive, but that also actually represent identifiable communities. Now, we have here a room full of lawyers. If, for homework, I set you to work and said, devise an optimal mechanism for redistricting fairness, I can confidently predict that not one of you would come up with anything like this, okay? I think that's fair. So Why do we do this? Well, it's compromise, right? I mean, it's clearly the product of back and forth. I wasn't in the room, but you can almost watch the silos growing. The General Assembly, we should do it. The Constitution says we can. Reformers, yeah, but, standards, how about our commission? So you can see how it came into being. Is it foolproof? No. Okay, it's not an independent commission. The General Assembly has a significant role. States with independent commissions are learning that's not foolproof either. The baseline criteria that I went over, there they are, don't mention avoiding a bias in favor of any party or incumbent. That comes into play only at the last silo where you're going with simple majority support. And for better, for worse, there's no representational fairness, no assertion that your districts in the end have to be balanced in the way the state is. Now, reformers were, we've been out there collecting signatures. We've been sold on what we're selling. We're not all on board with this, but the pragmatic perspective is the best reform is one that will pass, okay? In all the years since 1981, the only success occurred in 2015, where the General Assembly, through bipartisan negotiation, put something on the ballot. So in that way, you defang the opposition, and you get the cooperation of the Secretary of State office to have ballot language that the public can read and say, oh, I get this is a good idea. Because what's key is the little paragraph that the voter reads when they open up their ballot. And if they've never heard anything about it, that's all they read. They go, but if they understand it, they might say yes. But if it's written so they don't understand, they'll just say no. I understand that. Have you ever done that? You open the ballot, you go, hey, what the heck is this? No. Okay. So you really want a ballot initiative that is a fair description and also, helps nudge the voter. Okay. So the silver lining, if I may put it that way, is that the Arizona case that approved redistricting by an independent commission was a 5-4 vote. Justice Roberts penned a long dissent, joined by Justices Scalia, Alito, and Thomas. So the majority of 5 in the Arizona redistricting case says the Constitution says the legislature draws the lines. However, the people have legislative power. The term legislature is broad enough to encompass a measure adopted by the people in exercise of that power, and the people can designate an independent commission. The dissent offered a detailed, textual, and history-based argument that in Article 1, where it says, districts shall be prescribed in each state by the legislature thereof, it meant legislature, the representative body of the state, not an independent commission, not the people, okay? So this outcome, as a 5-4 decision, obviously, is somewhat vulnerable, particularly if you are going to be moving in a more text and history-based interpretation of the Constitution. But the Arizona case is distinguishable from what happened in Ohio. In Arizona, it was a popular initiative over the objection of the legislature and led to a process that cuts the legislature out of the process. They get to appoint 4 people, but beyond that, everything's done by the commission. Okay? Our Ohio reform was adopted after negotiations with the General Assembly. The General Assembly approved the measure to put it on the ballot. By the Ohio Constitution, the voters have to approve it after that. And the measure itself includes a role for the General Assembly. They get the first dibs, okay? So in the end, the Ohio measure we adopted could be safer from the effect of a future Supreme Court change of heart than the League's original initiative language would have been, okay? So we have a reform. Now what? Nothing, right? Nothing happens. Not on the 2015 reform, not on what we did in 2018, until after the census in 2020. So the first maps drawn under the new systems will not take effect until the election in 2022. So, in the words of the Beatles, the long and winding road, has it led us to the door? To the pending litigation. In May, right after the election, the League of Women Voters of Ohio signed on with some other plaintiffs to file a lawsuit in federal court challenging the 2011 district lines, not the reform. The lawsuit challenges the existing congressional district lines that will be in place until the election of 2022. So the litigation team is directed by the ACLU. There's a wonderful phalanx of lawyers on both sides. And it's before a 3-judge panel in the Southern District of Ohio. Hey, wait a minute. Why is it a 3-judge panel? Don't trial-level decisions usually heard by a single district court judge? Law, 28 U.S.C. 2284. Challenges to the constitutionality of the apportionment of congressional districts are heard by a 3-judge panel. This is one of the few instances. When you were in law school, you may have remembered 3-judge panels for all sorts of things. By and large, they were abolished. This is one of the few instances where we still have one. Appeals from the 3-judge panel go directly to the Supreme Court. So it's a shortened process. 3 judges at the outset, appeals directly to the Supreme Court. So our panel for this case is Judge Karen Nelson Moore of the 6th Circuit and 2 district court judges, Timothy Black and Michael Watson. One sits in Cincinnati, the other in Columbus. This is a trial-level proceeding, so it's an evidentiary proceeding. Now, there are multiple legal theories here. One is a First Amendment claim, that the map drawn in 2011 burdens the plaintiff's First Amendment rights because it was designed to disfavor them based on their political views. Well, who are these plaintiffs anyway? It's the Ohio A. Philip Randolph Institute, which represents minorities and unions, the League of Women Voters of Ohio, the College Democrats at The Ohio State University, the Northeast Ohio Young Black Democrats, the Hamilton County Young Democrats, and there are also 17 individual plaintiffs, human voters, one from each congressional district in Ohio. So we have a collection of plaintiffs, voters, and Democratic Party organizations. So burdens First Amendment rights. Second, the 2011 map burdens the right to vote. That would be for the individual plaintiffs. Third, the 2011 map intentionally discriminates against the plaintiffs by drawing district lines to dilute their votes on the basis of political association, packing and cracking. And then finally, the map exceeds the state's power under Article 1, drawn by the legislature, because it is a product of partisan gerrymandering. Now, the case is in litigation. These are the allegations in the complaint. The theories haven't been fleshed out in pleadings yet. We haven't tested them, and they haven't been tested in summary judgment or at trial. This is just what's being alleged. Okay. Current status. In August, the case survived a motion to dismiss, which I will get to, opinion by Judge Moore, unanimous panel. What was in the motion to dismiss? The first allegation was by the defendants, the case was a non-justiciable political question. This is where federal courts comes into play here. I love it. Okay, so what the heck is a political question? It is a federal court's doctrine where these are issues. The assertion is this is not an issue for the courts to decide. It's something allocated to the political branches, or it is something for which there is a lack of judicially discoverable and manageable standards. Okay? The Supreme Court has never held that partisan redistricting challenges are non-justiciable political questions. It has only expressed doubt about whether an appropriate metric can be found, and generally splinters. One of the most famous decisions on this topic back in 2004, 4 different opinions with, I know this is how we should do it, from 4 different justices. So pretty clearly, something can be found, but it hasn't been found yet. And the Supreme Court did not resolve this issue in either of the redistricting cases it heard this year because it jettisoned them both on other grounds, standing grounds, or before the merits grounds. So in our case, or rather in the pending Ohio case, because actually, the pending Ohio case, the plaintiffs have proposed several metrics to measure partisan gerrymandering. So in the panel's view, these, can proceed to be tested through the course of litigation. So, number 1, not a political question. Second, the defendants argued the plaintiffs did not have standing. Also a requirement to be in federal court, our plaintiff has to have a concrete, particularized, legally cognizable injury caused by the defendant and redressable in this litigation. You can't just complain about something and take it to federal court. You have to be personally harmed. We have, as you recall, several organizational plaintiffs and individuals from each congressional district. So the panel held that the plaintiffs had provided a prima facie demonstration of standing for all of their claims. In each instance, you had an organization or a human voter who could adequately allege the requisite injury to protected rights caused by the way districts are drawn and redressable by ordering the lines to be redrawn. And for this purpose, this litigation relies on a roadmap offered by Justice Kagan in her concurring opinion in the Wisconsin redistricting case this year, Gill versus Whitford, where she pretty much said, look, folks, if you want to have standing, this is how you do it. So the plaintiffs pretty much followed that roadmap. Now, the case is now in the third. Okay, so yes, standing. Third, the defendants argued the case was barred by laches. Hey, this is the 2011 map. Why are you only here now? But the court said this is not seeking to undo past elections, which would be a laches problem. Instead, we're seeking the plaintiffs are seeking prospective relief. Okay, so the case is now in the discovery stage. Experts filed information with the court on October 5th. They have offered several ways to measure partisan gerrymandering, under all of which Ohio is a partisan gerrymandering. And the email record I mentioned at the very beginning of this presentation shows evidence of that this effort was intentional. Okay, this case is set for 2 weeks of trial starting the first week of March 2019. So if successful, if it moves through trial and inevitable appeal to the Supreme Court quickly enough, this litigation could order the districts to be redrawn by 2020. In other words, redraw the current map. So the lawsuit potentially adds to the constitutional amendment adopted in May. It doesn't disrupt the amendment adopted in May. It's not about the amendment adopted in May. It's about the map drawn in 2011. But it potentially adds to it in two ways. Number one, maps could be redrawn sooner than 2022. And if the plaintiffs are successful, the litigation could add judicial standards to protect federal rights that in the ACLU's view are not adequately addressed in the Ohio constitutional reform that the voters approved in May. Recall that the criteria in the measure that was adopted in May didn't really talk very much, or indeed hardly at all, about balancing districts or to represent the views of the voters of Ohio, or avoiding favoring a party or candidate when you draw a district line. So, on this long and winding road that leads to the door to reform, right? We're standing on the front walk, okay? We haven't yet gotten to the door, and at this point, we don't really know what's behind the door. We have two sets of reforms, one in 2015 for the General Assembly, one in 2018 for Congress. Neither one has been tested yet, so we'll see what happens when we get there. Thank you. And yes, sir, question.
For the life of me, I can't figure out, even though the latches argument didn't work, why wasn't this lawsuit brought in 2012 or 2013 when we already knew what the effects were going to be? Why wait till 2018 when, at best, it might affect the 2020 election, but if the Supreme Court takes its time, we could get a favorable decision that wouldn't ever take any effect because we're going to go into the 2022. I've not been able to figure out the delay in bringing the lawsuit.
Well, I think one point is that the choice between ballot measure reform and litigation in Ohio, the approach was to try to get something on the ballot, which of course failed in 2012. And in terms of why wait, well, I can't answer that, not having been, party to people's thinking. But one value of waiting is we now have multiple cycles of elections, which underscore how resilient the district lines are in terms of partisan gerrymandering. And then the last point is, of course, if successful, you're right. I mean, you know, everything has to fall in line very quickly to make a single difference between 2022. But it could produce additional standards to assist the reform. So excellent question. Don't know why, but that's what happened.
So now that it's the Ohio Constitution that has been amended to address both the state legislative and the congressional districts, and we're waiting to see what's behind those doors, the thing I worry about as a civil rights lawyer is what are the remedies? So what provision has been made in those initiatives for private causes of action, for standing? Because it sounds like remedies for failure to comply or failure to apply the proper criteria are going to be Ohio court remedies. And that sounds like a disaster to me waiting to happen. So can you let us know who is it that can challenge if there's been a failure and what remedies are available?
Okay. In the measure, there is language that says any challenges to these maps go to the Ohio Supreme Court. Okay, that's in the state constitutional amendment that was passed. So if your challenge concerns the criteria under the Ohio Constitution, it will go to the Ohio Supreme Court using standing doctrines in effect in Ohio and legal tools available to you under Ohio law, seek an injunction, whatever. However, nothing in Ohio law can prevent access to federal courts if what you raise is a federal challenge. So, you know, the Ohio Constitution can't keep you out of federal court. So if you say this, you know, in addition to violating Ohio law, as a pendant claim, my main claim is a federal constitutional violation, then you would take it to federal court with the usual requirements of standing that would govern in federal court. So in addition to not knowing what's behind the door, we don't really know what will happen when people challenge it. So another very good question.
So if this challenge is going to court, the Phillips-Randolph case goes to court in March and the plaintiffs prevail, then it goes, the appeal would go directly to the Supreme Court. Now I know that there are different, it's a different question here versus the question that was resolved in Arizona, but we do know that the balance of the Supreme Court is different now. And so there's, you know, one, you know, Kavanaugh's there. How do you see the case going before that 5-4 majority?
Well, you know, it's hard to predict things, especially the future. It depends on what the case says. You know, I guess you couldn't predict that the case would be designed, if the plaintiffs win, the case would be designed to appeal to what will then be the governing interpretive philosophy of the newly constituted Supreme Court. And I think your guess is as good as mine, but certainly the balance will shift in favor of a more sort of text history, narrow original intent, which I'm not sure will get you anywhere, honestly, on this particular topic for the extent to which legislation can be done by the people. But it's a long way of saying, third question where we don't know the answer. Okay? Thank you. Any others? I want to be able to answer a question. So somebody asked me something really easy where you go, okay.
Really easy.
Oh, wow. Now I'm on the spot, though.
Okay, Hawaii and Alaska came into this is at the beginning of your talk, became states. What happened to take representatives from somewhere else to give it to Alaska and Hawaii?
let's see, Alaska, 1948, 1950, 58, 59. Oh, fascinating question. I don't know, darn it. This was supposed to be a question I could answer, but unfortunately my expertise in Alaska is also sorely lacking. You would guess that they would get their one, that the Constitution allows them, but then some other poor state. They must have reallocated at the time. Anybody know? Oh,
They would have done the 1960 census, and then, well, it was 59, so they would have increased it by 2 until the 1960 census.
okay. Okay, everyone, somebody can Google this. Any other useful questions? One of the points I said I was going to address in this talk is the relative role of citizen activism versus litigation, and so maybe that's a point to halt on or to wrap up on. You can see that under the Ohio Constitution there are various tools available for citizen action, and that where citizen action is available, it seems to have produced some results in the Ohio system without litigation. So the ability of the citizens to bring a measure to the ballot, which I think we can discuss in all of its hideous pros and cons based on looking at the rest of the Ohio Constitution, okay? I'm not globally advocating some of the amendments that have been added to our Ohio Constitution, but the ability of the citizenry to bring a measure before the voters, in this instance on this particular topic, is a very potent one where the legislators themselves have very little short-term incentive, and by and large short-term thinking prevails, very little short-term incentive to reform redistricting. Only if you take the long view and realize you might be on the outs as well as on the in, does it seem appropriate to make a change. And that was successful without litigation, that we didn't have to fight in Ohio to get something. That said, in states where that's not an option, litigation might be, in this particular topic, the only route. And, of course, in our own state, we have a compromise that produced a result that, you're welcome to go online and read it all and see if you can do better at the summary than I did. It's really not a beautiful thing to read. And then it is possible that the outcome of that ballot measure can be improved by the addition of standards adopted through litigation. So our fallback seems to be litigation. One last question, not about Alaska. Yes?
Right, they added two reps until they did the redistricting the next time.
So there were 437
Or it was
briefly.
a 60 election.
Okay, I wonder where they found them a desk. Okay, thank you very, one more. Yes, sir. The League of Women Voters itself, there's the national, and then each state has its own subsidiary. So in Pennsylvania, the litigation was led by the League of Women Voters of Pennsylvania. So overall, the League of Women Voters, being a nonpartisan group that favors effective voting and the informed electorate, is against drawing district lines on partisan grounds, and is for competitive districts so that your representative has to listen to you. But the precise strategy taken in each state depends on the legal tools available in that state.
But there are other jurisdictions where essentially the two parties are playing litigation chicken as opposed to trying to compromise the way we did here.
Well, there are states in which litigation is the option. There are a fair number of states that have ballot initiatives on the ballot this fall, in those states where that's an option. So, and then in other states, yes, it's litigation, Wisconsin, Texas, North Carolina, Maryland. All right. Well, thank you very much. Happy to take any additional questions after we break up. And now, thank you for being here, and enjoy the rest of your day.